I am, again, really angry that he is controlling the narrative.
These are the court documents making Jennifer Carroll upset. Her dad and stepmother, Lyman and Charlene Smith of Ventura, were just 2 of 12 murder victims tied to Joseph DeAngelo. It was her stepmother's DNA that led to his arrest nearly 4 decades after their murders. One of the motions filed Monday by the defense ultimately asked the court to dismiss charges DeAngelo faces outside of Sacramento County. Although not involved in the case, we went to Sacramento defense attorney Johnny Griffin to get a perspective.
The Constitution says you have a right to be tried by a jury of your peers in your community. So Mr. DeAngelo, he's charged here in Sacramento County for crimes committed in Sacramento County, but then they also charge him for crimes committed in 5 other counties. And the defense argument is he cannot be tried in this county for those crimes because those jurors aren't in Sacramento County. So he has a right to have a jury from those counties.
In that same filing, the defense added a footnote that DeAngelo would be willing to take a plea if the death penalty was off the table. Griffin says plea negotiations happen all the time. That's not unusual, but something else did strike him.
What's odd here is that they made those negotiations public. And what makes it even more curious to me, that affects the jury pool. Because if they don't reach an agreement and the case goes to trial, that jury is going to know that, hey, didn't this guy already offer to plead guilty?
He says making the plea discussions public could be a defense strategy.
It could also, as a tactic, help the defense in that they may take the position, we need a change of venue.
Whatever the reason, Carroll doesn't like it.
It's absolutely unacceptable. This should be something that has been discussed with the survivors and the people with charges pending before anything got made public.
Griffin questions one other filing by the prosecution asking for more DNA from DeAngelo.
Are they impliedly saying there was something wrong with the first sample?
Griffin told KCRA the motions themselves are typical in capital cases, but he wonders why they weren't filed before now. It's not clear when these motions will be heard before a judge. In Sacramento, Brandy Cummings, KCRA 3 News.